My name is Joe Sanborn. I am a retiree after having spent 42 some plus years at the teaching at the college level in criminal justice. My area of expertise is juvenile justice and criminal law, constitutional law. But most of my research has dealt with juvenile justice over the years. And essentially what my practical background is, I was a legal intern and consultant for the district attorney's office in Philadelphia. And also, I think what really rounded me out was being a consultant for the public defender's office in Philadelphia. And both of those offices dealt with juvenile exclusively. I really didn't deal with the criminal court and the prosecutors or public defender's office there. This is my third book, and it's the second relating to juvenile justice. I did an overall juvenile justice process book itself for Oxford Publishing a few years back. The driving force or motivation for doing this book was that the field of juvenile justice, particularly in dealing with transfer to criminal court, which is probably the most important decision stage in juvenile court, has been, in my opinion, it's been lopsided in favor of anti-transfer, or at least minimizing it almost to non-existence. I would say that honestly, 99.7% of the literature it's inundated with anti-transfer material. What I am trying to accomplish is that if any legislature or court wants to abolish transfer, I would like there to be a robust and comprehensive consideration of what is at stake if indeed transfer is eliminated or reduced to almost non-existence. I believe that comprehensive awareness is necessary because, as I point out, I believe in the book, there are serious repercussions and detriments to both juveniles and juvenile court if indeed transfer is so affected. So again, if a legislature wants to get rid of transfer or a court does, fine. But I'd like them to consider what I have in this book first. And currently, they won't find this material in any other source in the literature at all. I start out talking about what the anti-transfer camp, as I call them, one of the leading people in that area is Franklin Zimmering, who is a scholar in this field. But I think he's been, I guess, persuaded too much by anti-transfer type of thinking in the positions that he assumes. One of which is that indeed he thinks that, or he says that, juvenile court was founded solely, if you will, as a diversionary outlet for criminal court. And while that, and the point of it is that he's trying to make, I believe, is that if you have transfer to criminal court, well, that's a betrayal of why juvenile court was founded, because it's then reversing diversion back to criminal court. And what I would like to say about that is that, yes, juvenile court was founded in part for that reason, to avoid criminal court. I would suggest if you read chapter 2 in this book, you'll see I have 19 other very vital reasons as to why juvenile court was created. And those are actually, I think, more critical than diversion from criminal court, particularly with respect to that the juvenile court people wanted basically to deal with kids that criminal court either could not or would not address. So it wasn't avoiding criminal court as it was, you couldn't go to criminal court. If you look at the early years of juvenile court, it was predominantly it was a truancy, incorrigibility, running away from home. Those cases dominated the juvenile court, and those cases could not have been heard in criminal court. And juvenile court was also honestly about raising kids that the juvenile court founders believed weren't being raised properly. You could say there was some class connections here, some religious ones, ethnic ones, that juvenile court founders didn't like the ghettos in which many of these ethnicities were grouping, and they felt their kids weren't being raised right, and the juvenile court had to intervene and raise them. The same basic intervention occurred 100 years earlier with houses of refuge. when, in the early 1820s, houses of refuge were established to get mostly Irish kids out of the Northeast cities because the house of refuge people thought these kids were being ruined. Juvenile court did essentially the same thing. Now it was more Italian and Polish kids, but also Irish. And they wanted those kids out of the ghettos and away from parents who weren't raising kids properly. And the other major difference is that in the house of refuge, it wasn't a comprehensive program like juvenile court was. Juvenile court was all about kids, all juveniles, originally under the age of 16, because the first juvenile courts did not include 16 and 17-year-olds. And it was comprehensive. It was everything. It was misbehaviors and even non-misbehaviors. Kids growing up in idleness could be brought into juvenile court, and that's not an offense that I know of in any capacity, and certainly not something criminal court could hear. And again, the juvenile court founders, they wanted this court to be, private. They didn't like the idea of kids being, publicized. They didn't want kids to have any rights at all. In the houses of refuge, a lot of kids had gone through criminal court. Now they're going through juvenile court. They wouldn't have any rights. There would be no obstacles to juvenile court getting its hands on almost any kid. Any kid that was perceived to have a problem would be eligible for juvenile court intervention. There would be no obstacles to that intervention. And also they wanted the state to be cast as a friend and not an adversary. So, and the one way to do that was to portray the juvenile court and the system as purely benevolent, non-punitive at all, and to try to set that this is the same living you'd have at home if you had a good home. Now, chapter 2 lays that out in detail, and I think the reader would benefit from this because it draws heavily from the original publications about the juvenile court operation, which are very rare, actually, from the early 19 teens and 20s. And that's all in the second chapter. The third chapter puts to rest, I hope, the confusion and misrepresentation in what transfer is and what it is not. There's mandatory exclusion and not transfer, but mandatory exclusion if a kid is over the maximum age of juvenile court, and there's only 3 states left that do this, that have like a 17-year-old having to go to criminal court. And not too long ago, there were 13. We're down to 3, and I think that's actually a good sign. But then there's transfer, and there's really only 2 types of transfer: judicial transfer, obviously where a judge does it, or prosecutorial transfer. And chapter 3 lays this out with some real specificity, and I think the reader would benefit from it. Chapter 4 is, I think, a rare coverage of, now this is Philadelphia's juvenile court, because I was lucky to have access to the juvenile court annual reports from 1917 through 1978. And what chapter 4 lays out is the Philadelphia's juvenile court from those early years. And this chapter ends in 1939, because that's when Pennsylvania added 16 and 17-year-olds to the juvenile court jurisdiction, and everything there changed dramatically. Chapter 5 will disclose that indeed that change in how juvenile court became a clone of criminal court occurred really in the 50s and 60s and 70s rather than the 90s, when juvenile court violence spiked. But at any rate, getting back to chapter 4, you can see where the data, and there's many tables that lay out what exactly was going on in juvenile court at that point. And then from what I hear from other juvenile courts across the country, like Chicago and New York, Philadelphia paralleled it very well. It was the 3rd largest city, with those 2 other cities being larger, but Philadelphia was number 3 at that time. And I think it's very representative of the period and how juvenile court, and all those, the numbers and the data, they corroborate what chapter 2 alleges about the varied purposes of juvenile court, well beyond diversion from criminal court, and how juvenile court was really, it was a neighborhood resolution center. It was to operate on informality and do things where the neighborhood couldn't resolve something, or parents couldn't. If a parents had a problem child, go to juvenile court and get it resolved. At any rate, that chapter 4 lays it all out, how the institutions themselves were benevolent, as benign as possible, I guess, as any institution could be, and how it really operated as probably that original juvenile court that everybody does think of. Chapter 5 shows where the numbers changed dramatically. Everything changed dramatically. kids became older, and in some places this did start earlier. The 16 and 17-year-olds were added before 39, which happened again in Pennsylvania. But once those adult-like juveniles were added to juvenile court, you see the age obviously, ratcheting up, the offenses, the severity of the offenses, the number of offenses, especially the serious ones, the number of recidivists. And then the institutions were changing from child care centers to delinquent facilities. And it really changed. And what you'll see also, comparing chapters 4 to 5, where the 1917 data, and I wish I had earlier than that because juvenile court started in Pennsylvania in 1903, but the earliest records I could get were 1917. But even by 1917, the caseload of juvenile court in Philadelphia, 90%, runaways, truants, incorrigibilities, jumping onto real cars without paying, throwing stones, fishing without license. I mean, a whole bunch of things that were pure either status offenses or ordinance violations were what the juvenile court considered delinquencies. By the time the 40s, 50s, and 60s roll around, 90% of the caseload was robbery, rape, homicide, arson, burglary, auto theft. The juvenile court had really, by those dates, become more of a clone of criminal court. Chapter 6 starts to deal with, and chapter 6 to chapter 11 are all about really dismantling the literature and talking about where I believe at least the literature has gotten it wrong. So for an example, one of the things you'll see everywhere, TV, newsprint, anywhere, is that children when they're transferred to criminal court, they're being prosecuted as adults. No, they're not. There is not an age metamorphosis that goes on. It's about charging them or prosecuting them as criminals rather than as delinquents. But that mislabeling, I think, contributes to the campaign to dismantle it, to transfer, because, my God, we can't prosecute kids as adults, can we? And it seems inappropriate. And that's really, I think, a mischaracterization of what's going on. And there are other mischaracterizations as well. Offense exclusion is probably the number one target of the anti-transfer crowd. And what they are certainly into is, I think, trying to establish that it's, and offense exclusion itself is all about a crime itself that can't go to juvenile court. And it should be called offense exclusion. Calling it legislative or statutory transfer or waiver exclusion really is, it helps confuse the area because all transfer is legislative. It's the legislature that does it. All transfer provisions are in a statute. So calling something legislative or statutory transfer just makes, it creates a third type of transfer that honestly just doesn't exist. But at any rate, besides offense exclusion being mislabeled, it's also being mischaracterized as being mandatory or automatic or non-discretionary. What's very important to understand is it is not any of those. Offense exclusion requires a prosecutor to call an excluded crime. So for example, if murder is excluded and the prosecutor takes a death situation and calls it manslaughter, well, then that kid doesn't get transferred that way. So it really needs to be recognized as not being mandatory, automatic, or non-discretionary. And the literature is replete with descriptions of it being in that capacity. Then in chapter 7, and again, there's other items that I won't bother the reader with, but chapter 6 really does a detailed coverage of how many different ways in which offense exclusion and even judicial transfer is mischaracterized, and mandatory exclusion is mischaracterized. Chapter 7 gets into how the nature and effect of transfer is mischaracterized. So for example, there's allegations that the prosecutor's power to charge is unreviewable, basically total discretion. Well, that's not true because the prosecutor has to treat that case just like the prosecutor has to treat every case in criminal court. And they have to get by either a grand jury, a preliminary hearing, and a judge, and or a jury if it even goes to trial. So calling this unreviewable, et cetera, I think, basically just tries to flame, the terror and passions rather than describe what's really going on. Also, with respect to the prosecutorial transfer, there are those from the anti-transfer camp who will say it's a violation of separation of powers. Ironically, it's not a violation of separation of powers. Judicial transfer is, because judges are not allowed to charge people, and we don't allow. They're from the judicial branch. Charging belongs to the executive branch, where the prosecutor lives, and all that material belongs in the prosecutor's office. In conjunction with that, you'll have people like Franklin Zimmering and Barry Feld referring to transfer as sentencing. They're doing that because there are parallels, because the prosecutor is considering, what do I want out of this case, which is what a judge is considering in sentencing. But it's not sentencing, and it needs to be understood that it's not. And in fact, as I point out in Chapter 7, juvenile is being charged as a criminal, and the juvenile may never be convicted. So how is it sentencing? But I know what the anti-transfer crowd is doing. They're calling it sentencing so as to be able to say prosecutorial transfer is illegitimate or unconstitutional, and only judicial transfer, if we have to have it, only judicial transfer passes muster. And then we get into Chapter 8, where we basically get into arguments about why juvenile shouldn't be transferred to criminal court. And what the anti-transfer crowd has a tendency of doing is saying, like, if one transfer is bad, then all transfers are. If juveniles are more amenable to treatment, all juveniles are amenable to treatment. If juveniles are less mature, all juveniles are not mature. And basically, I try to disassemble that in Chapter 7. Also, another consideration is that the anti-transfer people say that transfer basically amounts to the criminalization of juvenile court. And what that's meaning to say is that juvenile court is becoming more like criminal court. Ironically, transfer allows for just the opposite, because by getting rid of the most chronic and violent offenders, we allow juvenile court to stay juvenile. If all those kids were retained in juvenile court, you threaten with it becoming more and more and more criminal court-like. And then also with respect to saying that juveniles are not as mature as adults, and then all juveniles are not mature. These are where singulars are converted into categoricals by the anti-transfer crowd. It's a good legal strategy, but it's one that I think fails on its merits. Chapter 9 is dedicated particularly to the argument that juveniles are not competent to stand trial in criminal court, whereas they're supposed to be competent in juvenile court. How that's possible is a conundrum, in as much as the two courts have the same standard of competency. So I try to take apart, if you will, the research that's been done in the area of finding supposed incompetency to stand trial. And one great irony there is most of the 14, 15-year-olds, let alone 16 and 17-year-olds, are found competent to stand trial by the tests implemented by the anti-transfer people, the developmental psychologists. And even though the data show that these kids are competent to stand trial, the developmental psychologists conclude that juveniles can't be transferred because they're not competent. And then again, I also talk about how many different faulty premises the developmental psychologists are relying upon in their research. Then in Chapter 10, I talk about how the anti-transfer crowd is trying to minimize the transfer target. If we have to have it, let's at least minimize it. And what they basically do is focus entirely on the offense. Then, in other words, let's make it only the very serious of offenses. And that's not illegitimate. It's just not the only game in town. Because if you have a very chronic offender, that individual is beyond juvenile court's help, assuming that indeed they've gone through, and many have, every juvenile court disposition available, and they still haven't turned it around. So saying that only serious offenses should go is simply shortchanging the target transfer itself. And then also with respect, they want only, Zimmering and Feld are big on this, where they want only those kids to go if there's a lengthier sentence needed than what juvenile court has to offer. And it's simply the formula just doesn't work at all, as I point out in this in Chapter 10, primarily or particularly because a lot of these kids who do auto thefts, and it could be their 15th or 20th for that matter, that the sentence in criminal court wouldn't be lengthier, but that doesn't mean the kid belongs in juvenile court. And then also chapter 11 gets into minimizing the transfer method, where the anti-transfer crowd has basically circled the wagons around judicial transfer is the only possible or permissible method of transfer. Chapter 12 basically does an analysis of the research, the transfer on research itself, and I'll let chapter 12 speak for itself, where I basically dissect it and show the weaknesses and problems attending that research. Finally, in chapters 13, 14, and 15, I talk about the benefits of transfer itself. And chapter 13 talks about juvenile court. I hinted on it before about if we don't have transfer, it will help criminalize juvenile court, make it that much worse, and take away from the public's perception and social acceptance of juvenile and the juvenile court's operation. In so many ways, juveniles would have to be given longer sentences for this to survive in juvie. They would have to be given more rights. Kids can't be getting 10, 15-year juvenile court sentences without jury trial, et cetera, which typically is denied them in juvenile court. And also keeping transfer helps juvenile court's rehabilitation mission. It helps its image and also the operation. If we don't transfer kids that would be on the top tier of juvenile court dispositions and facilities, the kids that are now confined in level 10 facilities, well, the ones who would have gone to 10 are now going to have to go to level 8, because 10 is occupied by all the would-be transfers. 8 is going to be occupied by those who should have been in 10, and et cetera. Down the line, there will be a trickle-down effect, and this one does work, regardless of what economics says. This one works because there's not going to be any room at the inn. And the kids who could have gone to a facility to get help, get out of the neighborhood, get out of the family, get some real schooling, are not going to be able to go there. They're going to be on probation for the 14th time because, again, there's no room at the inn. There are benefits to the kids. Well, because I think it keeps juvenile court alive, transfer does. And if juvenile court stays alive, the 90%, 95% of kids are benefited by that. Because if we get rid of juvenile court, if it dies due to no transfer, then I think many kids die with it. And the society as well. I think transfer benefits society where it has a proper balance of best interests. It protects, furthers community protection, and it does serve penal policies of justice, moral condemnation, proportionality, incapacitation, deterrence, and retribution. And I think for those reasons, and it actually allows for graduated sanctions. Putting a cap that no kid could go to criminal court makes obviously the most serious disposition in juvenile, the cap itself. And then God knows what happens to that kid on their first time in criminal court. Right now, in many jurisdictions, I've published an article about how many jurisdictions allow kids to take 2 strikes from juvenile court and strike out on their first pitch in criminal court. If you have juvenile courts retain all these kids, I don't know what effect that's going to have on factoring the juvenile court record into criminal court sentencing eventually, assuming these kids continue to reoffend. But I think it would only get worse. And then finally, chapter 16 puts the whole transfer policy idea into place, where I do recommend that we have offense exclusion and judicial transfer for the lessers, kids who are more chronic than they are serious in their offending, if they've, especially if they've utilized all juvenile court dispositions available, and that indeed, I think we want some availability of judicial transfer at that end. But for serious kids, I would argue that it shouldn't be about the kid. If you're talking about especially a violent offender who has done a homicide, or serious carjacking, et cetera, wherever a state wants to draw a line, above the line to me would qualify for offense exclusion. And it would be a statement saying that above that line, it really should be about society's interests, society's protection, much more so than a juvenile's. And by doing that, I honestly believe that those below the line who stay in juvenile court will be in an honest, realistic best interests system. As if you eliminate or reduce transfer considerably, I believe you threaten juvenile court's ability to maintain that best interest focus, because you're going to be dealing with murderers, rapists, et cetera, and possibly, obviously, if there's no transfer, on a continuous basis for as much as they want to reoffend. And in the opening quote of my book itself, I have something to say that responding to the violent offenses of youth who have no fear is daunting. responding to the violence offenses of youth with nothing to fear is terrifying.